After studying this module, we shall be able to understand the meaning of winding up of companies, know the difference between winding up and dissolution, learn the procedure of winding up of companies, learn the different modes of winding up, namely compulsory and voluntary winding up, and evaluate the difference between the two modes of winding up of a company.
Winding up is a means by which the dissolution of a company is brought about and its assets realized and applied in payment of its debts, and after satisfaction of the debts, the balance, if any, remaining is paid back to the members in proportion to their contribution made by them to the capital of the company. The liquidation or winding up of a company is the process whereby its life comes to an end and its property is administered for the benefit of its creators, creditors and members. An administrator called a liquidator is appointed and he takes control of the company, collects its assets, pays its debts and finally distributes any surplus remaining amongst members in accordance with their rights. Thus, winding up ultimately leads to dissolution of the company. In between winding up and dissolution, the legal entity of the company remains and it can be sued in the court of law or tribunal. On the other hand, a company is said to be dissolved when it ceases to exist as a corporate entity. On dissolution, the company's name shall be struck off by the registrar from the register of companies, and he shall also get this fact published in the official gazette. The dissolution thus puts an end to the existence of the company. Dissolution of a company may be brought about in any of the following ways: through transfer of a company's undertaking to another under a scheme of reconstruction or amalgamation. In such a case, the transferor company will be dissolved by an order of the tribunal without being wound up. Through the winding up of the company, wherein the assets of the company are realized and applied towards the payment of its liabilities, the surplus, if any, is distributed to the members of the company in accordance with their rights.
A company may be wound up in any of the following two ways. 1. Compulsory winding up, section 272, and voluntary winding up, section 304. Compulsory winding up. Winding up a company by an order of the tribunal is known as compulsory winding up. As per section 271, the tribunal may order for the winding up of a company on a petition submitted to it under section 272 on any of the following grounds. 1. Passing of special resolution for the winding up. When a company has, by passing a special resolution, resolved to be wound up by the tribunal, winding up order may be made by the tribunal. The resolution may be passed for any cause whatsoever. The tribunal may not order for the winding up if it finds it to be opposed to public interest or the interest of the company as a whole.
Inability to pay debts. As per section 271, subsection 2 of the Act, a company shall be deemed to be unable to pay its debts under the following circumstances. A. Notice for payment. If a creditor to whom the company owes a sum exceeding 1 lakh rupees has served on the company a demand for payment and the company has for 3 weeks thereafter neglected to pay the sum or otherwise satisfy the creditor, it shall be deemed that the company has become unable to pay its debt. It is essential that the debt is payable presently. Negligence in paying a debt on demand is omitting to pay without reasonable cause. Mere omission by itself will not amount to negligence. Further, where a debt is bona fide disputed, there is no negligence to pay. Failure to pay public deposits on their due dates amounts to inability to pay debts. A dividend, when declared, becomes a debt due by the company, and the shareholder can also apply for company's liquidation if the company is unable to pay his dividend.
Decree. If a decree or order issued by a tribunal or court in favor of a creditor of the company on execution remains unsatisfied on its execution. C. Commercial insolvency. If it is proved to the satisfaction of the tribunal that the company cannot pay its debts, this implies commercial insolvency when the company's assets are insufficient to meet its existing liabilities, as is disclosed by its balance sheet. The mere fact that the company is incurring losses does not mean that it is unable to pay its debts, for its assets may be more than its liabilities. Liabilities for this purpose will include all contingent and prospective liabilities, and even if the debt relied upon in the petition is disputed bona fide, the company may be wound up if the applicant can prove the insolvency of the company. However, non-payment of a bona fide disputed claim is no proof of insolvency. 3. Just and equitable. The tribunal may order for the winding up of a company if it thinks that there are just and equitable grounds for doing so. The tribunal has very large discretionary power in this case. This power has been given to the tribunal to safeguard the interests of the minority and the weaker group of members. The tribunal, before passing such an order, will take into account the interest of the shareholders, creditors, employees, and also the general public. The tribunal may also refuse to grant an order for the compulsory winding up of the company if it is of the opinion that some other remedy is available to the petitioner to redress his grievances and that the demand for the winding up of the company is unreasonable. 4. If the company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years. 5. If the company has acted against the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality. 6. If on an application made by the registrar or any other person authorized by the central government by notification under this Act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, or the company was formed for fraudulent and unlawful purpose, or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and that it is proper that the company be wound up. Section 272 provides that the petition for compulsory winding up of a company may be filed in the tribunal by any of the following persons. 1. Company. A company can make a petition to the tribunal for its winding up by an order of the tribunal when the members of the company have resolved by passing a special resolution to wind up the affairs of the company. Managing director or the directors cannot file such a petition on their own unless they do it on behalf of the company and with the proper authority of the members in the general meeting. Section 272, subsection 5. 2. Creditors. A creditor may make a petition to the tribunal for the winding up of the company when he is able to prove that the company is unable to pay off his debts exceeding 1 lakh within 3 weeks of the notice of demand, or where a decree or any other process issued by the tribunal in favor of a creditor of a company is returned unsatisfied in whole or in part. The law does not recognize any difference between the secured and unsecured creditors for this purpose. A secured creditor is as much entitled as of right to file a petition as an unsecured creditor. But in case of a secured creditor's petition, winding up order shall not be made where the security is adequate and no other creditor supports the petition. A contingent or prospective creditor can also file a winding up petition if he obtains the prior consent of the tribunal. The tribunal shall grant the permission only when 1. It is satisfied that there is a prima facie case for the winding up of the company, and 2. The creditor provides such security for costs as the tribunal thinks reasonable. The tribunal may, before passing a winding up order on a creditor's petition, ascertain the wishes of other creditors. If the majority of the creditors in value oppose, and the tribunal, having regard to the company's assets and liabilities, considers the opposition reasonable, it may refuse to pass a winding up order. 3. Contributories. A contributory shall be entitled to present a petition for the winding up of a company, notwithstanding that he may be the holder of fully paid up shares, or that the company may have no assets at all, or may have no surplus assets left for distribution among the shareholders after the satisfaction of its liabilities and shares, in respect of which he is a contributory, or some of them were either originally allotted to him or have been held by him and registered in his name for at least 6 months during the 18 months immediately before the commencement of the winding up, or have devolved on him through the death of a former holder. Section 272, subsection 3. 4. Registrar. Registrar may, with the previous sanction of the central government, make the petition to the tribunal for the winding up of the company only in the following cases: when it appears that the company has become unable to pay debts from the accounts of the company, or from the report of the inspectors appointed by the central government under section 210, or if the company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years. If the company has acted against the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, or morality. If on an application made by the registrar or any other person authorized by the central government by notification under this Act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, or the company was formed for fraudulent and unlawful purpose, or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and that it is proper that the company be wound up. On the commencement of the winding up of a company, its shareholders are termed as contributories. Voluntary winding up. Winding up by the creditors or members without any intervention of the tribunal is termed as voluntary winding up. According to Section 304, a company may be wound up voluntarily. 1. By passing an ordinary resolution in the general meeting. A. When the period for the duration of which the company was constituted has expired. Or B. When the event on the happening of which depended the termination of the existence of the company has happened. 2. By passing a special resolution to wind up voluntarily for any reason whatsoever. Within 14 days of the passing of the resolution, the company shall give notice of the resolution by advertisement in the official gazette and also in some newspapers circulating in the district of the registered office of the company. Every officer responsible for default in publishing the resolution shall be punishable with fine extending up to rupees 5,000 for every day of the default. Section 307. Types of voluntary winding up. Voluntary winding up of a company is of two kinds. A. Members voluntary winding up. B. Creditors voluntary winding up. Members voluntary winding up requires the filing of a statutory declaration of solvency by the majority of the directors of the company with the registrar. Where the company is not in a position to pay off its liabilities in full, the voluntary winding up is termed as the creditor's voluntary winding up. In such a case, declaration of solvency shall not be made and filed with the registrar. Members' voluntary winding up. Voluntary winding up of a company which is solvent is termed as members' voluntary winding up. It requires the filing of a statutory declaration of solvency by the majority of the directors of the company with the registrar, besides a resolution of the members of the company, ordinary or special as the case may be, which is to be passed at the general meeting of the company. 1. Declaration of Solvency. Section 305. In the case of members' voluntary winding up, two directors or the majority of the directors of the company, where there are more than two, are required to make at the meeting of the board of directors and file with the registrar a statutory declaration of the solvency of the company verified by an affidavit to the effect that they have made a full inquiry into the affairs of the company, and having done so, they have formed an opinion that the company has no debts or that it will be able to pay its debt in full within the time specified in the declaration, but not exceeding 3 years from the commencement of the winding up. 2. Appointment of liquidators. After the declaration of solvency has been filed by the directors with the registrar, a resolution will be passed by the members for voluntary winding up of the company. In the same meeting or at any subsequent general meeting, the company may appoint one or more liquidators as may be thought necessary, and fix his or their remuneration if any. Such remuneration, once fixed, cannot be increased under any circumstances. The liquidator shall not take charge of his office before the fixation of his remuneration. 3. Managerial personnel's powers to seize on the appointment of liquidator. On the appointment of a liquidator, all powers of the board of directors and of the managing or whole-time directors and manager, if any, shall cease, except for the purpose of giving notice to the registrar regarding the appointment of the liquidator, or to the extent as allowed by the company in the general meeting, or the liquidator may sanction the continuance thereof. Section 313. 4. Power to fill up vacancy in the office of the liquidator. If a vacancy occurs by death, resignation, or otherwise in the office of the liquidator appointed by the company in a general meeting may fill up the vacancy. The general meeting for this purpose may be convened by any contributory or by a continuing liquidator or liquidators, if any. Section 312. 5. Notice of appointment of liquidator to be given to the registrar. The company shall give notice to the registrar regarding the appointment of liquidator within 10 days of his appointment. In case of default, the company and every officer of the company, including the liquidator who is in default, shall be punishable with fine which may extend to rupees 1,000 for every day during which the default continues. 6. Power of the liquidator to accept shares. Section 494 provides that the liquidator cannot accept shares, policies, or like interests in consideration of the sale of the company's undertaking to another company with an object to distribute them amongst the members of the transferor company unless 1. A special resolution is passed by the company to that effect, and 2. He purchases the interest of any dissenting member at a price to be determined by agreement or by arbitration. 7. Duty of liquidator to call creditors' meeting in the case of insolvency. If at any time the liquidator is of the opinion that the company will not be able to pay its creditors in full within the period stated in the declaration of solvency, or that period has expired without debts having been paid in full, he shall forthwith summon a meeting of creditors and shall lay before the meeting a statement of the assets and liabilities of the company. Thereafter, the winding up shall proceed as if it were a creditor's voluntary winding up. 8. Duty of liquidator to call general meeting at the end of each year. The company liquidator shall report quarterly on the progress of winding up of the company in such form and in such manner as may be prescribed to the members and creditors, and shall also call a meeting of the members and the creditors as and when necessary, but at least one meeting each of creditors and members in every quarter, and apprise them of the progress of the winding up of the company in such form and in such manner as may be prescribed. 9. Final meeting and dissolution. As soon as the affairs of the company are fully wound up, the liquidator shall a. Make up an account of the winding up, showing how the winding up has been conducted and the property has been disposed of, and b. Call a general meeting of the company for the purpose of laying the account before it and giving any explanation thereof. Creditors' voluntary winding up. Where the company is not in a position to pay off its liabilities in full, the voluntary winding up is termed as the creditor's voluntary winding up. In such a case, declaration of solvency shall not be made and filed with the registrar. In creditors' voluntary winding up, the creditors are given a controlling voice in the winding up of the company. 1. Meeting of the members and creditors. The company is required to call two meetings, one of the members and the other of the creditors of the company, to pass the resolution of the winding up separately at both the meetings. The meeting of the creditors shall be called by giving notice to the creditors simultaneously with the notice to its members, and by publishing the notice in the official gazette and two newspapers circulating in the district of the registered office of the company, will call a meeting of the creditors either on the same day or the day next to the day when the resolution for voluntary winding up is passed by the members. Board of Directors of the company will lay in the creditors' meeting a full statement of the position of the company's affairs, a list of creditors of the company, and estimated amount of their claims. The creditors' meeting will be presided over by one of the directors appointed for this purpose by the board. At the meeting of creditors, a resolution shall be deemed to be passed when a majority in number and value of the creditors present, personally or by proxy, and voting on the resolution, have voted in favor of the resolution. 2. Notice of resolution to registrar. Section 306, subsection 4 provides that a copy of the resolution passed at the creditors' meeting shall be filed by the company with the registrar within 10 days of the passing thereof. 3. Appointment of company liquidator. Section 310, subsection 1 provides that the company in its general meeting, where a resolution of voluntary winding up is passed, shall appoint a company liquidator from the panel prepared by the central government for the purpose of winding up its affairs and distributing the assets of the company, and recommend the fee to be paid to the company liquidator. Section 310, subsection 2 provides that the appointment of company liquidator shall be effective only after it is approved by the majority of creditors in value of the company. Where the creditors do not approve the appointment of such company liquidator, creditors shall appoint another company liquidator. 4. Fixing of liquidator remuneration. The creditors may fix up the remuneration to be paid to the liquidator or liquidators. Any remuneration so fixed cannot be increased in any circumstance, either with or without the sanction of the tribunal. 5. Board's powers to seize on the appointment of the liquidator. Section 313 provides that on the appointment of a liquidator, all the powers of the Board of Directors shall cease, except in so far as the creditors in general meeting may sanction the continuance thereof. 6. Power to fill vacancy in the office of the liquidator. Section 312 provides if a vacancy occurs by death, resignation, or otherwise in the office of a liquidator, other than a liquidator appointed by or by the direction of the court, the creditors in general meeting may fill up the vacancy. 7. Duty of liquidator to call meetings of company and of creditors at the end of each year. In the event of winding up continuing for more than 1 year, the liquidator shall a. Call a general meeting of the company and a meeting of the creditors at the end of the first year from the commencement of winding up, and at the end of each succeeding year, or as soon thereof as may be convenient, within 3 months from the end of the year or such longer period as the central government may allow, and B. Lay before the meeting an account of his acts and dealings and of the conduct of winding up during the preceding years. 8. Final meeting and dissolution. Section 318 provides that as soon as the affairs of the company are fully wound up, the liquidator shall a. Make up an account of the winding up, showing how the winding up has been conducted and the property has been disposed of, and b. Call a general meeting of the members and a meeting of the creditors of the company for the purpose of laying the account before it and giving any explanation thereof.
Let us now recapitulate what we have learned in this module. Winding up is a means by which the dissolution of a company is brought about. A company may be wound up in any of the two ways: compulsory winding up and voluntary winding up. Winding up by a company by an order of the tribunal is known as compulsory winding up. Winding up by creditors or members without any intervention of the tribunal is termed as voluntary winding up. Where the company is not in a position to pay off its liabilities in full, the voluntary winding up is termed as creditors' voluntary winding up. The members of a company on the commencement of winding up are termed as contributory.